Hi, everyone. My name is Diya Mathews. I am a partner and attorney at the Edison offices of Chugh LLP. I'm here to talk to you about two major developments as a result of new regulations imposed by the Department of Homeland Security and the Department of Labor, which have far-reaching consequences for H-1B work visas, as well as for certain other visa categories, and also for labor certification of firm-based employer-sponsored green cards. Now, the Department of Labor rule has immediate effect. It basically overhauls the wage leveling system for H-1B workers and also for other visa categories which need an LCA, such as the E3. Now, what is the labor condition application or the LCA? It's basically a contract between an H-1B employer and the Department of Labor. It mandates certain obligations that the H-1B employer has to meet, such as when it comes to the payment of wages. The H-1B employer has to pay wages to the worker in accordance with the wage level set by the Department of Labor. So the Department of Labor has certain wage levels that are prescribed for H-1B workers, and the employer, the H-1B sponsoring employer, has to pay the wages in accordance with these wage levels. What has happened now is that the level 1 wage itself for most categories and in most areas has increased substantially. And the level 1 wage salary has now become equivalent to what used to be the level 3 wage salary. So it's a drastic increase in the salary payable to the H-1B worker. Just as an example, if you look at the level 1 salary for software developers in Middlesex County, New Jersey, which is where I am, that used to be about $79,000 per year before. And now as a result of this new regulation, of the jump in the wages, it's now gone up to about $116,000 per year. And this is just the level 1 wage. The DHS rule, on the other hand, we have a little more time for that. That goes into effect around the first week of December. And basically, it tightens the requirements for establishing an employer-employee relationship in the context of an H-1B petition, and also the definition of a specialty occupation. Now, this has been on the agenda, on the Department of Homeland Security's agenda for a while, so it's not really surprising. And in fact, all it does is it codifies most of what we have been seeing in terms of the issues raised by Department of Homeland Security in RFEs that we have been receiving in the last couple of years. So the Department of Homeland Security's new rule basically now says that there has to be a direct relationship between the degree requirement for any position and the duties of the position. So again, as I said, we have actually been responding to RFEs in the last couple of years with this sort of information. So it's not really news in that sense, but they have clarified now that general degrees such as engineering or liberal arts and business administration, these kind of degrees are no longer considered to be specific enough to qualify as a specialty occupation. So employers will need to now demonstrate that the degree requirement is specific and that it directly relates to the duties that the person will be performing in the job. There will also be additional requirements for third-party placements. Third-party placements are when consulting companies place their workers at client sites. And now we have to go back to giving contracts between all the layers, all the vendors, client letters, and all of that. The other requirement is that H-1B approvals for third-party placements will also now be given only in 1-year increments. So you can get extensions, but when it comes to third-party placements, they have said that they will only give these approvals in 1-year increments. Basically, what we see is that these two regulations have kind of set us back. We had a reprieve from many of these RFE issues as a result of the IT serve litigation, but now these two rules kind of undo the positive work that was done by the IT serve litigation, and now we are going back to the old Neufeld memo requirements that were set out in 2010. What is the way forward? I'd say that the chances of these regulations being challenged in court are fairly high. The regular rulemaking process was not followed. The public was not given enough time. Notice and comment was not really properly done. And the rules will have significant impact for H-1B employers. Besides, there's not really much evidence that these measures will really improve things for the local workforce, which is, what they say is the objective of doing this on a rush basis. The expectation is that these regulations will be challenged in court, and that we'll get an injunction fairly soon. So that remains to be seen. The immediate concern for most H-1B employers and for employers sponsoring green cards through the labor certification is how to tackle the quite unexpected jump in the prevailing wage as a result of the Department of Labor's regulation. One of the options, as you might know, might be to use an alternate wage survey or a private survey. And in fact, many practitioners have been using these alternate wage surveys, especially for areas where the Department of Labor OES wage has historically been very high. We can use the alternate wage survey, and there's quite a few options out there. We have to be careful utilizing them because the wage survey that is used has to meet certain requirements set by the Department of Labor. So if they don't meet the requirements, then they will Department of Labor will just reject them, and they will default to the OES wage. So the use of an alternate or the private wage survey, I think, is what most H-1B employers will fall back on. In terms of the DHS regulation, we have some more time. That goes into effect, as I said, only by the first week of December. So it might be a good idea to strategize with your immigration practitioner and see if you can file your extensions or any upcoming amendments quickly before that. So that's recommended for the time being. As always, please contact your trusted Chugh LLP attorney or practitioner for more detailed advice. Thank you.